appeal in the matter of E. Khawaja and Stefanova and Wars.
Yes, Mr Howard.
I appear for the appellant Ms Stefanova, and then friend Mr Roseman responds.
Yes.
The list, I think, shows an application ahead of the substantive appeal.
Well, I think they've listed an application with the appeal. As I understand it, the only outstanding application is the application to adduce fresh evidence, the respondent's application to adduce fresh evidence.
Yes.
Yes. What I think we would prefer is for you to make your arguments on the appeal. We will then consider where we are, and we will then decide how to deal with Mr Roseman's application. But I would not expect you in your submissions to anticipate either the application or indeed the respondent's notice points. We think they're probably better left until they've been developed.
Right.
If that suits you.
That suits me, my lord, yes.
Yes.
In that case, I'll begin by stating the obvious. This is an appeal against sentence, and the issue is whether 8 months was too much for this series of contempts found as found. And I make this obvious point at the start as, I hope, a prophylactic against getting too entangled in the thickets and weeds which have sprouted, in this case, to an unusual degree. The test is, I'll come to the authorities for ipsissima verba and slightly more development, but broadly can be summarised as wrong in principle or manifestly excessive.
Yes.
I propose to follow the course indicated in my skeleton argument with a couple of variations. I will start by trying to set out the way the case is developed so far as relevant to the decision that the judge had to make on the 29th of March. That will take a little time, but it will make my eventual submissions on the grounds of appeal much shorter. In fact, they'll be reduced, some of them, to effectively a mention, because it will come out in the course of the facts as I explain them. And then look at the authorities, and then summarise the actual findings of contempt, and then look at the grounds of appeal against the judgment of Mr Justice Richard Smith.
Yes.
And I was proposing finally to respond to the respondent's notice points, but very briefly, because many of them in my submission are in the category of thickets and weeds. The dispute arises from an oral agreement between two individuals to go into business together to exploit a business opportunity. We have the pleading at the beginning of the supplemental bundle. You'll have seen the particulars of claim. It's all about an opportunity in relation to product made by a firm called Luminera, who make cosmetic cum medico products, wrinkle remedies, and are based in Israel. That was in April 2018. The vehicle for the business was a limited company which had already been incorporated by Ms Stefanova. They fell out very, very early on, and she proceeded alone, pursuing a one-woman business working from home. He issued his claim in August of 2020, and trial was in the autumn of 2021, preliminary issues, and the judgment was delivered on the 6th of October and is in the supplementary bundle at page 31. And the operative passage for present purposes is in paragraphs 33 to 37, and the core of it is in my skeleton argument. But it's to be found in the supplementary bundle at, the judgment starts at 31 of the supplementary bundle, and the important bit is on 38.
Page 38, paragraph 33, conclusion, there was a binding contract.
That's right, there was a contract. At this point, I'm not prepared, he says in 34, to make an order for specific performance because there is insufficient material before me. The reason I say is it appears possible the second defendant no longer contracts with Luminera, it is possible that not presently known she may have a completely different business from the cosmetic filler business. It might be possible that there's a midway point, which is the second defendant still supplies and distributes cosmetic fillers, not from Luminera but from another supplier. Well, that's prophetic, certainly, because that's exactly what it turned out to be the situation when she provided the evidence. So he required some evidence to be provided by her and gave directions. And the order, which was agreed by part of counsel, is at 41. File and serve a witness statement in respect of the period 1st of April 18 to the date of this order, which is the 8th of October 21, setting out details of what's happened about Luminera and Panaxia Limited.
I'm sorry, where is this order?
This is 41. This is the order he made.
Thank you.
And this is what he required in the way of information from the defendant. That's at 2. A, what's become of the Luminera contract, whether or not she's entered into contractual or other arrangements or taken supplies from any supplier of products substantially similar, and if so, details thereof and other business activities undertaken, together with production over the page of all the second defendant's financial statements and accounting documentation, including bank statements and tax returns, bank statements of bank account, which the first defendant has been a signatory in any document relevant to and supportive or anything said in the witness statement pursuant to paragraph 2. So that's for the period which ends on the date of the order, the 8th of October. And she applied for an extension of time and it was granted. That's now relied on as an instance of her continuously disobeying orders, but she applied for an extension and it was granted, and then she delivered her witness statements and documents on the deadline ordered by the extension. And it's at 53 in the supplementary bundle, and it's a very substantial piece of work. So it starts at 44 on the supplementary bundle, and it's a very substantial piece of work. And it reveals that she has indeed stopped trading with Luminera, but she is trading with other suppliers of products in the same class. And at page 52 to 3, you will see the level of detail that is provided about the trading history and status of the company in issue, Derma Med. And you'll see in particular, she describes the history at paragraph 22, how she stopped dealing with the claimant. She says it's because he didn't keep up the payments on request. After that date, at 23, the business was exclusively funded by way of my borrowing against my personal mortgage. At paragraph 24, I have always and continue to run the second defendant on my own, don't have any employees. Due to my hard work and efforts over the past few years, I have a current relationship with suppliers and customers. And then at 25, there's a great deal of data set out in a series of documents which are explained in 25.1, because this is going to come up, 25.2, all expenses invoices for the period 1st of April 18 to the 10th of January 20, and then at 25.3, a printout from her software of expenses from the 10th of January 20 to October 2021. Now, she explains over the page on paragraph 26 that she had only realised that her accounting software package would do expenses as well with effect from the 10th of January 2020, which is why she provides all the invoices up to that date and a nice printout thereafter. Because it's one of the things that's questioned, she goes on at paragraph 29 to deal with various categories of documents which she's been asked to deliver, and explains the position. Round about the middle of the page, paragraph, I work night and day, including weekends, to make relationships with suppliers and customers and set up the training academy. I'm also a single mother with a young daughter and try my best. And on the next page at 30, it's very difficult for me to attribute the expenses of the second defendant to individual contracts or product lines. They can generally be categorised as follows: warehousing costs with access self-storage. So I'm not going to read it all out because we'll be here forever. But, that's the substance of what was done. It cost her, she said, £25,000 to her solicitors to get that work done. And obviously it disclosed that the Luminera trading having ended, the case was in fact, as far as disposal was concerned, absolutely on the midway point identified as a possibility by Judge Gerald in his judgment.
So what do you mean by it?
The midway point, he said there might be a midway point whereby the Luminera contract has ended, but she is trading in similar products. It's in midway point was the term used by Judge Gerald in paragraph 34.
Where did she say? I'm sorry, you did refer to it.
The Luminera is over. And earlier on in the witness statement, she says that it has ended. Bottom of page 47, paragraph 13. My last order with Luminera was made on the 5th of May 2019.
And when you said the case is absolutely on, you mean the claim for breach of contract or specific performance is...
Well, Judge Gerald had identified, as when he was giving his reasons why he wasn't going to give specific performance because he wanted to know more. It is possible, but not presently known, that she may have a completely different business. It might, of course, be possible that there is a midway point, which is the second defendant still supplies and distributes cosmetic fillers, but not from Luminera, but from another supplier. None of that is presently known. Well, after this witness statement, it was known, and indeed, he was right. It was indeed on exactly that midway point. So there's clearly a question to be decided about how the remedies were to be calculated and allotted and indeed in the first place claimed.
Yeah.
Because the claim was all about the claim identified in the particular claim starts with a business opportunity to exploit, namely Luminera, and so it would need an investigation which was not done for the purposes of the judgment, which merely established there was an agreement. Does the scope of that agreement go beyond that one business opportunity? Does it go on into similar products with different suppliers? What would happen if one developed into further products that were slightly different? And what happens if the parties fall out and no longer wish to be with each other? All of this would need to be worked out, and all of that is reserved, not having been determined at the trial. The next thing that happens is that Judge Gerald had ordered, along with the filing of the witness statement and production of the documents, that there would be a case management hearing on the 10th of December. Well, that got taken out at the same time that the deadline for providing the evidence was extended. It was stood out, I think, to a date to be fixed sometime after the middle of January, but somehow I don't know where the position was when the next thing in the story happens, which is that the Part 18 request is served on the 4th of April. Which is in the supplementary bundle starting at page 58 and is 12 pages of very detailed requests going through to 71. Look at a couple of items only. On page 63, paragraph 15.2 gives you the flavour. The defendants are requested to clarify and find full particulars as to whether the defendants admit that in circumstances where the court found the first defendant to be dishonest and invented evidence, and that the claimant did in fact comply with contractual obligations. The first defendant's decisions to allegedly borrow against her personal mortgage, you'll recall that's the paragraph I read out, that was how she financed the business from then on, and or any charges with such lending activity are solely down to her own failure to request further monies from the claimant. Lord, it was information she was providing in order to inform the next stage of the litigation. It wasn't at that point, in my submission, appropriate to be getting into allegation and cross-allegation. At 65 in the supplementary bundle, paragraph 19, which refers to paragraph 28 of the witness statement, and the passage is quoted on the previous page, with no waiver of privilege. I've been advised that this is to do with the expense report. There is a question, a bow drawn at adventure, at 18.3, whether the first defendant has made any payments out of the second defendant's bank account to pay for any legal services in respect of the dispute with the claimant, and if so, the dates and amounts of such payment. That is a point. And eventually the total is identified, or very within a small percentage of an accurate figure, but not the full dates and amounts of each payment. And that's obviously a relevant consideration. And that was, in fact, one of the controversial issues on the hearing before the judge, as to whether sufficient information had been given to satisfy the order. At 19.2, my Lord will see that the defendants are requested to provide copies of a complete expenses report.
Can I just butt in for a second and just ask, why are you getting into this level of granular detail? Because, I mean, the order that was made following this Part 18 was the order that stood.
Yes.
There's no appeal against the judge's findings of contempt. I'm struggling at the moment to understand where this, what you're trying to get us to get from this level of detail.
I'm trying to establish the generally exorbitant degree of requirement, and I do accept.
But does it lie in your mouth to say that in relation to an order which was not appealed? Well,
it does in relation to the contumely. I suppose it's the sheer burden of what was being imposed when she's punished for failing to match up to that.
But how can you say that this court should say that an order previously made by another court which wasn't appealed was exorbitant?
Well, I'm not. I'm asking. I'm submitting that her failure to comply. Eventually, we get to the point where she is punished for contempt of court for failing to provide a detailed breakdown of the legal payments when she has provided the overall figure. That relevant to the penalty are, first of all, the effort that she made to comply. Secondly, the harm that is done, in particular, the harm that is done by the failure to comply, in the sense of prejudice to the other side who should be receiving this information and need it for the purposes of developing their case. In my submission, a very, very high percentage of what was being ordered and of the failures that are then subsequently penalised as contempt of court had negligible impact on the claimant's capacity for developing his case. In fact, what we do have is the startling situation that the defendant was, the claimant was in fact ordered to explain in a short and clear form, an outline of the facts, what it is that the remedy that he is seeking. This happens later on. It's contested. And there's a passage in my learned friend's skeleton argument which is, to me, disconcerting, because he quotes a passage from my skeleton argument and says that the submission is disingenuous. This is.
Are we taking you out of your order? Or do you want to deal with this?
Well, I was going to just fill in a little bit of the rest of the story before I get to it, but this is it. We have a very strange piece of litigation going on here, where essentially satellite applications are burgeoning and developing more and more. And this is where it all begins, because there's this extremely hefty demand for enormously granular detail. I mean, for example, my lord, just to say, it is ordered. I accept that it's ordered. I query whether it should have been, but since it was ordered, the question is what punishment is deserved when it's not fully complied with. The passage that I was in the request on the supplementary bundle, page 65, 19.2. What's demanded is a complete expense report covering the period 6th of April 2019 to the 5th of April 2022. Now, my lord will recall, I just mentioned that she had given all the invoices up to the 10th of January because the computer, which generates a nice handy report all on a spreadsheet automatically in date order and everything else, wasn't used by her for expenses until that date. So she gives them a printout from the 10th of January, and prior to that she gives them the invoices. Here, it is demanded that she provide a complete expense report for the preceding section. So they've got the raw data, they've got the invoices, but they're not prepared to crunch the numbers themselves. They want her to do it. Well, it was ordered, and she failed to do it, and she was found to be in contempt of it. But in my submission, when you look for contumely and when you look for harm in that breach, and it applies to many of them, it is very difficult to identify either to any significant extent at all, certainly any extent that could possibly cross a custody threshold.
Thank you.
That is indeed ordered, and the substantive order. There was resistance. You've seen the reply. It's in the same bundle. It took the point that this was disproportionate. The point was then argued in front of Judge Gerald, and Judge Gerald made an order and ordered the 4.5 pages of closely typed schedules, which eventually we see in Judge Parfitt's order, which includes the penal notice and therefore forms the foundation for the contempt application in the county court.
So the order of Judge Gerald that you say it was made, that's at 88, is it?
The first one, where it's I think it was on May the 20th, where he orders the response,
In the way that
which is on page 88 of the supplementary bundle.
the way that county court orders do, it bears two dates. There's a date at the bottom, which is 13th of May, and the date at the top right, which is 20th of May. I've always understood the date at the bottom to be the date the order was
My lord,
pronounced, and the date at the top to be the date it was
yeah,
sealed.
my lord, you're absolutely right. I read the wrong one.
Yeah.
Wrong date. You're absolutely right. You're absolutely right. Yes, that's the date. The date of the seal, I think, is the one at the top, and the date of the hearing is the one.
It takes
at the
some
bottom.
time sometimes for these orders to be drawn up.
Yes, and particularly if a minute has to be circulated between councils, for example.
That order, the one at 88, refers to Schedule 1 and Schedule 2. We don't actually have them in the bundle, but I
No.
understand you to say that the ones that are Schedule 2 is on a Judge Parfitt's order are identical.
Exactly.
Yes.
Which we do have in the bundle at 122 through to 127. But the schedules are 123 to 7. And it's 4.5 pages of very closely typed detail.
As I understand it, there were actually 3 successive orders. There's the one on the 13th of May, which set a deadline of 24th of June. There's then an extension by His Honour Judge Gerald at page 121,
Yes,
which
my lord.
extends it to 5th of August, and then it comes before His Honour Judge Parfitt.
That's right. Now, my lord, I would draw your attention to 121, which is the July order,
Yes.
because in that order, That one we don't seem to have.
It doesn't seem to have a date.
That's at the bottom of the week. Well, that's the order that's sealed on the 11th of July anyway.
Yes.
Paragraph 2. The judge ordered that the claimant shall file and serve written submissions to confirm his position in respect of whether the first defendant has complied with paragraph 1 of the order. And there's no condition, not and if he agrees that he is satisfied, just and, in respect of the relief he is seeking in these proceedings. And this is where it comes to the troubling, or the very disconcerting submission that appears in my learned friend's skeleton argument, because the passage appears at page 63 of the core bundle.
You could just give me a moment. This order extends the time to 5th of August, and then the idea is 4 weeks later, claimant will say, am I now satisfied, and what relief am I now seeking?
Yes.
Yes.
Now, my lord, at page 63 of the core bundle, my learned friend refers to my skeleton argument.
I think you,
Actually, the passage starts on the page.
I was going to say you need to start at 62, don't you?
Yeah. And what he's quoting there is my words in my skeleton argument. So this is not Ms Stefanova. And the first submission, he says, is disingenuous, as Ms Stefanova is fully aware that since the 6th of October 2021, the County Court proceedings have been conducted on the basis that, unless and until S, I think that should be K, S complies with the court's order for her to provide information and documentation, S, and I think that should be K, will be unable to precisely quantify the damages he seeks in lieu and or in addition to the grant of specific performance. Now, Lord, I was obviously troubled by that, and I checked, and it's not in the bundle before your lordships, but was before Mr Justice Richard Smith, the order that is subsequently made by His Honour Judge Gerald on the 28th of February of this year, and I can pass that up if there's some means of passing it up.
Well, my lords, this is an application for fresh evidence to rely on additional documentation. Presumably, this whole issue regarding the adequacy of our pleading is actually subject to an appeal. But all of this happened well after the hearing before Mr Justice Richard Smith, my lords.
Well, my lord, the order of the 28th of February 2023 happened before the hearing before Mr Justice Richard Smith, which was at the end of March.
Well, let's have a look at it.
And the order of the 28th of February 2023 was in the bundle before Mr Justice Richard Smith. There's a second one there which you may also need to hear submissions on, and I won't refer you to just for the moment.
Well, we've heard that Mr Roseman objects to it, but I suggest that we look at it on a provisional basis, and
yes,
we'll hear submissions on what, if any, reliance can be placed on this, once you've understood what the point is. What is the point?
My lord, the point is that His Honour Judge Gerald, in February this year, ordered again, at number 2 of the order, the claimant file and serve a statement of case setting out the relief sought and the broad factual basis thereof, which appears to be at odds with what is said in paragraph 48 of my learned friend's skeleton argument. Now, my learned friend has mentioned that there's an appeal going on. I'd better fill you in on what happened next, although this was not known to Mr Justice Richard Smith. He knew about he'd had in his papers the order of the 28th of February. But on the 17th of May, again, His Honour Judge Gerald, who is, let us not forget the trial judge, who has not finished his work yet.
Yes.
There is a hearing in which he finds that the document served by the claimant in purported compliance with the order, that is to say paragraph 2 of the order of the 24th of February, i.e. file a statement of case setting out relief sought and broad factual basis of it. The document served in purported compliance with the order fails to set out the relief sought and the broad factual basis thereof, and therefore His Honour Judge Gerald ordered these proceedings be stayed for a period of 28 days, and unless the claimant by 4 p.m. on the 9th of June issues an application to lift the stay and files and serves a statement of case which sets out the relief sought and the broad factual basis thereof, the claim stands struck out. That has been appealed. My understanding is that it's in the works, and no doubt a single judge of the Chancery Division will be deciding whether or not to grant permission to appeal in due course. But on the face of it, the claim is in fact actually struck out at the moment for want of provision of a statement of case setting out the basis for the claim, as ordered as far back as July last year.
My lord, sorry, that is simply not true. That is simply not true. My learned friend is saying, and I'm surprised he is saying it, and I apologise for interjecting. Just to correct my learned friend, and I appreciate he wasn't counsel dealing with it, the head of his chambers, Mr David Berkeley, King's Counsel, was dealing with it. But to correct my learned friend, His Honour Judge Gerald took issue with our pleading, served, we say, in compliance with the order of the 24th of February, my lords. The judge then, in our view, retrospectively interpreted his order in a way which didn't make any sense, said, well, you didn't comply with the order. We then made an application to lift the stay and filed a further statement of case, whilst at the same time appealing, just to protect Mr Khawaja. There is no order to the effect that our particulars of claim have been struck out. What my learned friend is saying is entirely incorrect.
Right, I'm sorry, the bit I didn't know about was that a new Mark II statement of case has been filed in compliance with the order. So in that case, we're not struck out then. In that case, that's a misunderstanding on my part.
My understanding of what you are saying is that you object to a personal allegation of disingenuous behaviour which is made by Mr Roseman against you personally in paragraphs 47 and 48 of his skeleton argument.
I certainly do.
And you are saying that it is not supported and can be seen to be an unjustified allegation against you by reference to these two orders, which indicate that Judge Gerald doesn't think that it in fact is clear, or didn't at that stage think it was clear, the basis upon which Mr Khawaja's case was being advanced.
That's exactly right, my lord. That's exactly right. What I understand has happened since is an application has been made to the High Court as appellate court, asking for an order that Judge Gerald be removed from the case altogether on grounds of bias, which was dismissed with costs recently.
Sorry, my lord. What my learned friend is saying again is not correct. I've sat down. A great deal of what he's saying actually is factually incorrect. But with regards to, just so your lordships are aware, His Honour Judge Gerald made an order which I've mentioned. We made an application to lift the stay and to file the further pleading, but we did it without prejudice to our position that His Honour Judge Gerald was wrong for reaching his decision. We have appealed his order. I think the order was made in May 2023. One of the grounds of appeal is apparent bias. We have transcripts where His Honour Judge Gerald has been, in effect, abusive, unpleasant and rude during the course of hearings, a number of hearings. That appeal is not subject to any determination. We're still waiting to hear from the High Court. What we did was, to prevent any further conduct happening in the county court pending the outcome of our appeals, make an application to the High Court to stay the county court proceedings. That order, that application came before the Applications Court a few weeks ago, and the High Court wasn't minded, but took the view that the appropriate place for us to make such an application would be the county court. We then made an application for His Honour Judge Jebel to recuse himself, the judge having reserved every single matter to himself since, every single hearing of the matter since 2021. Inexplicably, Judge Jebel then released the application for him to recuse himself to a recorder and sat on other matters on the day the application took place, which led to the application being adjourned. So that, my lords, is the accurate summary of where we are.
Thank you. I can see why you say that there's burgeoning ancillary applications, Mr Howard.
Lord, yes.
Can we go back to the point you wanted to make?
Yes.
Which is that you objected to the
Yes.
allegation, you being disingenuous in your skeleton argument. What is it that you said in your skeleton argument which is complained of?
What I said in my skeleton argument, which is objected to, is paragraph 32 of my skeleton argument, which is to be found in the core bundle at
Well, I think the skeleton in the core has been
modified, that's right. So the pagination will have changed. But it's paragraph 32. It was on page 24. And this part did not get modified. What I said was, this is ground 1, subground 1. Excessive and exorbitant nature of the task that was set to her. The litigation concerning, a very short summary, total deficiencies less than $500,000 after 4 years of trading. The stage reached in the action was remedied. Information needed to decide on that. That was in October 21, and in June 23, the claimant has still not stated his case in a form and manner acceptable to the trial judge. My lord, that is still true.
Yeah. But what one needs to look at the dates. The respondent skeleton argument, as I understand it, is dated in May. Is that right?
Yes.
8th of May. So it's not responding to this version of your skeleton.
Well, he
to
quotes
the original version.
He quotes what he is responding to.
I think you can get there very easily, can't you? You simply, in paragraph 32, the words in italics are what.
That's right.
If you ignore the words in italics,
Exactly.
you have what was being objected to, or what was being said to be disingenuous. And so it previously read, that was in October 2021, and in April 2023.
Yes.
C has still not stated his case, despite having enough information to file a petition alleging losses with detail and precision.
Correct.
And what was, I believe, said in May was that was disingenuous, because since 2021 the county court proceedings is being conducted on the basis that unless until S complies with the court orders to provide information and documentation, R will be enabled to precisely quantify the damages he seeks. And you say that isn't the case. Look at the order that was originally made for a statement of case setting out the relief sought on the broad factual basis to be provided, and that was still the case in February 2023.
Lord, yes. That's right.
And
My lord, you're not helped perhaps by the little update, apart from just to get a flavour of quite how
I don't
hard-fought these
think
proceedings
the
are.
update really goes to your objection. Your objection goes to the allegation in May. What you said in April was disingenuous. What you said in April was they've not stated their case yet, despite being able to plead a petition. My understanding is that is factually correct, that no document setting out their case had been filed by April.
That's right.
That's the case. What Mr. Roseman wants to say is, well, that's because we didn't have the information. And I think your objection is to the use of the word disingenuous, because all you were saying was they haven't stated their case yet, which was true.
Yes, exactly.
Mr. Esmond, we don't expect you to reply to this now, but when we get to you, I'm very concerned this appeal should not go into all the ramifications of every aspect of this case which have happened since. But it is noticeable that your skeleton makes a number of allegations in quite extreme terms, such as dishonest and disingenuous, and if those allegations are made not only against parties but against counsel, I think you are entitled to explain why you made the allegations in those terms, because it is obviously something that should only be done if there's material to justify it. Now, I don't expect you to answer that now, and as far as I'm concerned, Mr. Howard, I have your point, unless you want to develop any further.
No, thank you. So, my Lord, we get to September and Judge Parfitt makes the order that he makes. And by this point, as she has said, she's spent £114,000 odd of costs. Of much of it out of the company's bank account, perhaps even all of it out of the company's account, as is identified and objected to, but it's a fact, that's what she's spent. And she cannot afford more. She's been given a quote to comply with this latest order of £30,000 plus more to deal with correspondence. And so she writes in, including the information about the £114,000. It's at the back of the supplementary bundle, and she includes some attachments. And she says also to the judge that she doesn't wish to work with Mr Khawaja anymore. Now, she's at this point and from now on...
Sorry, can you give us the reference to that?
365 to 367. The whole long letter actually begins on 356 and is addressed to the court and is dated the 15th of September. So it's received by Judge Parfitt. I think he has it before him on the occasion of the hearing. But anyway, he makes the order. She's now unrepresented by qualified legal professionals. She has Mr Partovi, her Mackenzie friend, who is dauntless but not legally qualified, and that's her only protection. The order is made and she attempts to respond in November, and that attempt to respond is...
the order made is...
The order of Judge Parfitt is made at 122 of the supplementary bundle.
Sorry, that's the one we were looking at.
And she then responds by the deadline, 4th of November, at 285. And this is a substantial document which one needs to turn up. This is her with the help of Mr Partovi, and it runs for 7 pages, 285 to 291, and answers some questions, answers a lot. But the answers are eventually found to be insufficient. Just to take you to a couple of samples, because they're relevant, they relate to counts eventually considered by the judge. On 288, paragraph 6.1, the first defendant did pay for legal expenses from the second defendant and has already provided bank statements showing her paying such legal expenses from the second defendant, which has been provided to the court in the claimant at the last hearing. There was a further additional roughly $3,600 paid for legal expenses in this claim form from the first defendant's personal bank account. This is not in any way a a complete detailed account showing exact sums and dates as ordered. And so we'll get to the judge's conclusion on that later on. 7, the defendants do not provide training academy. What the claimant is referring to is advanced aesthetic training sessions where doctors and nurses are trained on how to use the products. That's said to be insufficient, and the point was argued and determined by Mr Justice Richard Smith against Ms Stefanova for reasons which I'll show you. But just to show no job too small, on page 291 at 16, this is responding to question 16 in the Schedule 1 of the order. Botox SH is a good friend of the first defendant. His name is Razvan. He wanted to buy the first defendant's daughter a gift, and so busy he transferred the sum of £210 to her account so she can purchase Victoria, who is the 10-year-old daughter, AirPods for her birthday, which she did. Bank statement is at 323, which had been provided long before. Back, I think this is part of, and this is the question, is based on these payments, bill payment from the Botox SH, £60, and I think it's 50, or it might be 150. There seems to be a slight glitch in the copying. No detail too small to be included in the order. Now, I take my Lord's point. It was ordered and there was no appeal. But when we come to consider failure to comply, that particular one, in the end, was on the contempt application from the County Court, but was not pursued at the actual hearing. It was considered that she'd given an adequate explanation, and the fact that she hadn't provided the documentation to support those transactions was not pursued as a contempt of court. In the end, she did comply. At that same place, in her letter of November, we have something, and 291. This is a good example. Number 17. This question is too broad and unreasonable, and she says she just can't face doing it. Now, what that request was is in half its order at number 17 under Schedule 1, which is on page 125 of the supplementary bundle, at the very bottom of the page. It takes some reading. You start at the bottom of paragraph 17. The first defendant is requested to clarify.
Just a minute, I'm sorry.
125, my lord.
Yeah, I know. Sorry, you just have to give me a second to get there.
Right down the bottom. Right down the bottom, the first defendant is requested to clarify in full particulars as to the source of each said cash payment. This is, sorry, in relation to all cash payments made into the bank account from 1st of April 18 to the date of this request. And we go back up, the bank account is identified about halfway up the page, bank account with the reference Stella above number 11. All cash transactions for 4 and a bit years. And she says it acts too broad and unreasonable. Well, my lord, actually she did manage it in the end with the help of solicitors and counsel on legal aid. We did about 2 weeks' work in 1 week, an adjournment having been refused. And in fact, it actually wasn't so difficult. There was a table in 2 pages of her affidavit, which I know you've seen, and there are about 40 transactions in the end once one went through every single bank statement and picked them out, and we were able to tabulate them. And in fact, that was not complete because my learned friend was able to point me to another code in the bank statements which indicated cash transactions, and there was another, I forget how many it was, I think it was between 7 and 10 further transactions were thereby identified, and we'll see what the judge made of all of that. Clearly, she had failed to comply with the order clearly she was in contempt. But that's the level of it. Now, Lord, the High Court action, which is the second half, the other 4 months of penalty that you're required to consider, was by petition presented in December following a Norwich Pharmacal order and the obtaining of all the bank statements, which enabled the claimant, or as he by then is now petitioner, to issue a petition in the High Court alleging receipt, identifying with some precision payments out of company money to the defendant of 452.3 thousand, credit given for £2,000 a month of salary for 56 months, meaning a misappropriation alleged of 340,000.3, and diversion of the company's business because she had allowed one company to, the first company, to cease trading and had taken out other moved the trading, renewed the trading with the second company. Freezing orders were obtained of £500,000 on the basis of, with disclosure provisions. The 500 was based on 250 conservative estimate of the value of net profits since April 18, plus 250 of costs, which was said to be 100 so far and 150 going forward. So we're talking about a not particularly enormous business. Contempts 25 to 30 concerned breaches in the order of committal, concerned breaches of the disclosure provisions in the freezing order and subsequent renewal of freezing order. Not quite sure how 6 contempts were identified, ended up in the order when only 5 allegations are scheduled in the notice of application, but it's all concurrent, and therefore it needn't trouble this court to.
It was treated for sentencing purposes as one group.
Exactly.
Yes.
Exactly, and that's absolutely right.
Yes.
What the actual substance of it is failure to provide bank statements. Quite a limited period. You'll see from the notice of application that it starts in October, and those were in the end all provided up to date. I think, although if there was some outstanding, part of the suspension of the order was on the basis that they would be provided. So they are in the end provided, but they were not provided in time and in accordance with the order. There was no obvious need for there to be 2 separate allegations, one for failing to disclose and then one for failing to confirm on affidavit. Didn't really need to be 2, but anyway it was. That's the bank statements. The other group of allegations, or pairs of allegations, is failing to disclose and failing to confirm on affidavit assets to the value of more than £1,000. And this is a purely technical of absolutely no harm or interest whatsoever to anybody in my submission. It is that she had failed to write in and say, I own 100% of the shares in the new company and I own 50% of the shares in Dermamed, which were facts which were not just known to the claimant but pleaded by him as the foundation of his petition, and both of those companies named in the petition as respondents. However, there are 2 contempts, one of failing to disclose that and one of failing to follow it up with an affidavit. Now, that brings us to the 28th of March, or rather the 27th of March, which is the date of her affidavit, and my lords will have read that affidavit. It's in the core bundle and it is absolutely material and does not count as thickets and weeds for the purposes of this exercise. It's absolutely central. The further effort that was made to produce that was intense and was substantial, and the result you have read. The result is also to be found in the table attached to the judgment, and that's in the core bundle of 163 to 165. And you'll have seen that rather convenient table. And I'm particularly drawing attention to the 5th column of that table, which is...
Sorry, when you said a moment ago that the affidavit that was served by your client was central and we should have read it.
I mean, it's in the core bundle, my lord, and it's in the core bundle. It's at starts at page 212 of the core bundle, and it's quite lengthy.
215, perhaps.
Sorry, 215. You're absolutely right. I'm so sorry, my lord.
Right, but
to 242. It's a substantial piece of work in my submission, which goes through carefully and as thoroughly as possible all the things. I think for present purposes it's perhaps sufficient to look at the table on 163 to 165, and you'll see in the 5th column, which is date of compliance, sorry, when complied, Zaccaroli, Mr Justice Zaccaroli, provisions about disclosing her shareholdings in the two companies, or about disclosing her assets, in brackets shares, because those are the assets that are complained about as not having been mentioned. And you can see there's 2 of them. One's the disclose, one's the confirm on affidavit. When complied, 27th of March, that's the affidavit that she provided, i.e. it's on the eve of the hearing. And you'll see in that column on the next 2 pages that there are a number of entries, several of the lines for 27th of March. And that's because this is what she's done with that affidavit. She has provided the information that was ordered, and for want of provision she has been found to be in contempt, and admits being in contempt by providing the information in that affidavit. Some are contested, and on the disputes of fact, I just ask you to look at some in the judgment itself, looking at page 156, paragraph 17. This is the judgment on the contested allegations of breach, 7 contested, 1 of which she was acquitted and 6 she was not. And you'll see at 17 is concerning the legal expenses, which I've touched on already, and you'll see that she refers to the 100 in the middle. Her letter of the 16th of September refers to $114,000 of expenses. That's the letter I mentioned in the supplementary bundle at 256. And there's a list of dated payments in an exhibit supplied then, apparently to solicitors' firms. The source of these payments is not identified. Having considered the documents, I'm sure she was in breach of paragraph 6 to schedule 1. Nowhere does she sufficiently identify that payments were made by the first respondent from a bank account of the second respondent, nor is there a breakdown or complete breakdown of payments by date and amount. That is the harm. Second live item, paragraph 18. The present respondent, the claimant, knew what the amounts were. Paragraph 18 is training academy, which is an expression which she had used. I set up a training academy in her original statement of November the previous year but 21. And she has given a fuller explanation. It's 3 or 4 short paragraphs in her affidavit which say a little bit more about what it consisted of, that people were invited and a doctor would explain what to do with the products, and it was a selling opportunity and networking opportunity as well as training opportunity, and that was held by the judge to be an elaboration, which means that because she'd said more than she said first time round, he concluded that she had therefore failed to comply with the original order, which was to give full particulars. So she shot herself in the foot there by giving more detail, but it it is, as far as mischief and harm to the claimant's case is concerned, again, impossible to identify what difficulty he has with developing his claim for the lack of information identified there as a contempt. And
but hang on,
I could take you through all the pages if you like.
No, this is a case where, as is often the case, one side suspects that the other has been engaging in conduct secretly or behind their back, which should have been done through the company.
Yeah.
That's the nature of the allegation. If somebody doesn't explain fully and properly at the first stage what's been actually has been done, which is within their own knowledge, what it spawns is further suspicion, requests, so that the party who is entitled to the information gets it.
Yeah.
And so, obviously, once, in a sense, the information has been provided, you can say, well, it's been provided and they can get on and do what they were doing. The difficulty with this type of situation is always that because the information is not provided accurately on the first occasion or when it's ordered, further suspicion is engendered, further cost is incurred, because people naturally don't trust each other, then have to develop further arguments, pursue further arguments. I mean, that's what's going on.
This case is an example of exactly that process happening.
Yes, but although you say that
levels of suspicion have got more and more elevated with every step of the way, and every explanation that's given is, well, that's not exactly what you said before, so I want to know what exactly you mean. And so it goes on.
But when you say no harm is engendered by the breach, the first breach, I'm just trying to understand what you mean by
prejudice to the claimant's case, or prejudice to the claimant even, lasting and substantial prejudice to him. It's not like we're not in the territory of a large amount of money has been concealed, or it's what is required at the moment is that he is able to go before Judge Gerald and explain what it is that he is after, and to identify what it is that he is after, he needs certain information, as Judge Gerald does eventually, to decide the case. That's what this whole thing is all about, and it's just been spiralling down and down and down into ever more detailed demands, which Ms Stefanova eventually does provide a little further information.
I understand. I mean, let me take two scenarios. I mean, the purpose of the information disclosure requirements with a freezing injunction is to enable policing of the injunction.
Yes.
A freezing injunction is designed to preserve the defendant's assets.
Yes.
To satisfy an ultimate judgment. I understand the argument that if, for example, the disclosure is not given at an early stage, and I'm not talking now about this case, I'm talking just in general terms, if disclosure is not given at the early stage, and that prevents the claimant from policing the injunction, and if as a consequence there is a dissipation of assets which goes undetected and as it were was unable to be stopped and the money may have gone, then I understand you'd say that's a long-term prejudice to the claimant caused by the contempt. That's not this case you're saying. You're saying
no.
This is a case where the information has been provided and there's just simply delay in providing the information, but the fact that the order couldn't be policed in the meantime has not caused any long-term damage.
Yes.
But in a sense, other than the fact that there's a ramping up of the suspicion and costs incurred in the meantime, because if it had been provided right at the start, in a sense that the claimant wouldn't have been pursuing the matter further.
My lord, yes.
That's the distinction, as I understand it, that one could draw in relation to this case. So you're saying it's not a case of the first time, although you presumably would accept that it would have been better and costs would have been saved and the like if the information had been provided when ordered rather than belatedly.
My Lord, perhaps one thing one might do is just contrast what was provided with what was later provided, and found which was found to be, I assume was found to be sufficient. Her remarks on Training Academy are on page 230 of the core bundle, and her information that she had supplied in accordance with Judge Parfitt's order, i.e. by the 4th of November, is on 288 of the supplementary bundle. Taking the first one, which is 288 of the supplementary bundle, I've taken you to it already, it's paragraph 7. And what she says about it is on page 230 of the core bundle, and there's 4 paragraphs. I take my Lord's point. The question was asked, it wasn't answered as fully as it could have been. In terms of contumely, in terms of harm, in terms of penalty after she has given the further explanation in her affidavit and thereby purged that particular problem. This is a Part 18 request for information, drilling down into a witness statement ordered in order to provide information about the business that she's been doing. And if she's balked at providing it as fully, or has failed to provide it as fully the first time out, well, that may be so, but when you need to consider penalty, this is so far away from some of the stuff I'm going to come to in the authorities, where people have salted away millions and sat on their hands in somewhere like British Virgin Islands or Kazakhstan and refused to cooperate with orders. This couldn't be further from that. And now actually come to the authorities, my Lord. There's a bundle which you have, I hope. Which is paginated, and I'll just refer to the page numbers in the bundle.
So what you're saying, just to wrap that point finally, though, is that in paragraph 18 of his judgment, core 156, page 156, although you don't dispute that the judge was right to find that your client was in breach of paragraph 7 of Schedule 1 in relation to the first provision of information, you say that what the judge hasn't done is to take into account that although it's a breach of minimal consequence.
Well, breach of minimal consequence, unfortunately, isn't a defence. Contempt of court is pretty strict liability, as I understand it. So when it is found...
What you're saying is... No, sorry, but what you're saying is for sentencing purposes.
For sentencing purposes, yes.
You're saying that the judge has not, by simply saying that it was a breach, when he, I think you're teeing up the submission that when you later come to look at sentencing and you look at the intent or the blameworthiness of the breach, that this is, for example, a good illustration, you say, probably, hopefully your best illustration from your point of view, but it's an illustration that this was, a breach, therefore technically, or therefore a contempt, but not a continuous...
Yes, and my Lord, I haven't started with the most trivial. I mean, I started with legal expenses, which was obviously a significant matter. I'm just taking
all I'm trying to do is
taking the first two out of the 7 that the judge dealt
Yeah.
with in his judgment as contested issues. I'm trying to be fair in the sampling here, but the overall submission which I do make is that as far as the county court information requirements are concerned, the actual damage done by being deprived of the information is hard to identify and modest. And there are at least some situations where the level of demand for information, I mean, for example, failing to give a detailed breakdown of the cash, the expenses. Very difficult to do, and they'd got the material already. That was something that was interrogated for. I can't actually remember whether that was a contempt or not. No doubt. But the general situation is that in the context of what's being required, she's spent £25,000 on her first compliance with the order back in 2021. She's then run out of puff for paying solicitors, and going it alone has produced an effort which is inadequate in the November in response to the order with the penal notice. She's then, with legal aid and some very hard work, put together what she has done ahead of the actual hearing at the time she's in front of the judge. And from the table we can see that many of these contempts have been satisfied. Some, I argued the toss on her behalf, and most of them was found against, but that's one of them. Whether
Now, just be sure I understand. The judge suspended the sentences on the basis that the information that was missing was provided.
Yes.
Has that been done?
My instructions are yes. I may well hear otherwise from my right, I don't know, but my instructions are yes, and I'm certainly not aware of any application for the suspended sentence to be activated. Yes. So I'm taking it that for present purposes it has.
I mean, strictly speaking, that doesn't seem to me to be relevant to the exercise we're embarked on, which is whether at the date of sentencing the sentence was appropriate or not.
Yes.
And subsequent events can't affect that.
Yes.
But just as a matter of fact, your instructions are that
yes,
you have complied with the condition on which the
yes.
sentence was suspended.
Yes.
Yes. Thank you.
That's my understanding of the position. Yes.
Thank you. You wanted to go to the authorities. That's all you want to say on the fact.
That's my account of the story so far, which
yes.
is also, as you've already
it
encompassed quite a lot of my
your
submissions. Yes, it totally has. Absolutely. Looking at the authorities, I started at the back of the bundle with Business Mortgage Finance 4 PLC and Hussein in this court, and right at the back of that judgment,
Sorry, just give us a second.
I think my lord was in. Yes, indeed. My lord would be very familiar with this one.
I didn't do the
You didn't
lead
do the
judgment on the sentencing,
No,
which is what
Lord
you want.
Justice Arnold did, and
Yes.
you agreed, and he sets out at page 125 of the bundle, almost the very end, he sets out authority which in my copy is highlighted. I think it has come up highlighted.
Yes, mine is.
Pages 118, paragraphs 118, 119 and 120. Quoting the Supreme Court, which has referred to Liverpool, Victoria and Khan. And number 1, assess the seriousness of the conduct by reference to the offender's culpability and the harm caused, intended or likely to be caused. And that's why I've been mentioning harm and prejudice. In the light of its determination of seriousness, first consider whether a fine would be sufficient. If it's so serious, only custodial would suffice. Impose the shortest period of imprisonment which properly reflects the seriousness of the contempt. Due weight given to matters of mitigation such as genuine remorse, and I accept that the judge found rather against Ms Stefanova on remorse, but previous positive character, well, that's challenged, but in my submission she's entitled to the the fact that she's not been in this kind of trouble ever before, that is a fact, and similar matters. Due weight should also be given to the impact of committal on persons other than the contempt law, and the judge did indeed take into account the position of her daughter, and who no obvious arrangements for care, and that no doubt also fed into the suspension of the sentence, along with the condition to ensure compliance with one of the disclosure orders. A reduction for an early admission of the contempt to be calculated consistently with the approach set out in the Sentencing Council's guidelines. And it is said elsewhere in these kinds of proceedings that sentencing in civil contempt is rather less, hasn't quite such detailed and elaborate nuances and gradations as criminal courts are prescribed to apply in relation to a guilty plea, but 1/3 off for a timeless guilty plea is certainly correct. And over the page...
sorry, what's the purpose of that submission? You get 1/3 off if you admit guilt at the first available opportunity.
That's so in the criminal court, yes.
Yes, sorry. How do you say that?
Descending to about 20% in the face of the when the jury's about to be sworn.
About 10%, I think, actually. Unless they've changed it.
Anyway, well, my lord, I haven't practiced in the Crown Court since it got refined.
But I mean, we haven't got the sentencing counselling guidelines in the bundle, not even in relation to totality.
No. Lord,
are you going to come to how that applies, you say, to the facts of the present case?
Yes.
Yes.
Yes. So I'm just drawing attention to the overall. Yes. Quite right. I was getting ahead of my jumbling in. I'll try and maintain discipline. There's more on guidance in paragraph 119 from Lord Justice Arnold, quoting the familiar authority of Lord Donaldson in Lightfoot and Lightfoot, the purposes, and mentioning Solodchenko, which I will turn to, and then at page 120, the other familiar checklist, which goes back to Lord Justice, to Mr Justice, he then was Lawrence Collins in Metric, Crystal News in Metric, as glossed by Mr Justice Popplewell in Asia Islamic and Drum Risk Management. Whether the claimant has been prejudiced by virtue of contempt, that list at the bottom, the extent to which the contempt was acted under pressure, the breach of the order was deliberate or unintentional, degree of culpability, whether she's cooperated, and so on. Now, the facts of that case are obviously completely different, relentlessly habitual contemnor who even attended the appeal by remote link from Hoseley Bay, where he was serving another sentence for contempt, and then refused to, and then switched off after he didn't get it an adjournment. And he got the maximum and quite right too. Tab 5 is ocrity, which was mentioned by the judge. That's at page 44, and contains a similar checklist at Schedule 1, which I don't think that's necessary to look at because it really says all the same sort of thing. Culpability and harm are high on the list of the important considerations for seriousness, and the judge found this to be authority specifically for non-compliance with disclosure orders. Such breaches in the context of freezing orders as here indicate that condign punishment normally means a prison sentence, and in the cases of continuing failure to disclose, the court should consider imposing a long sentence, possibly even a maximum of 2 years. That's in his sentencing remarks, which are paragraph 30, and I'll come to them again, but I'll just mention it now so you have it in mind. I think that actually isn't in ocrity at all, but is in fact in Solodchenko, which is page 33 of the bundle, Lord Justice Jackson, at paragraph 55 at the bottom of the page, I think is the passage that the judge was wrongly attributing to Otkriti. From this review of authority, I derived the following propositions concerning sentence for civil contempt when such contempt consists of non-compliance with the disclosure provisions of a freezing order. Freezing orders are made for good reason. Any substantial breach of such an order is a serious matter which merits condign punishment. Condign punishment for such contempt normally means a prison sentence. However, there may be circumstances in which a substantial fine is sufficient. For example, if it's been purged and the relevant assets recovered. Well, no relevant assets have been lost. Where there is a continuing failure to disclose relevant information, the court should consider imposing a long sentence, possibly even a maximum of 2 years, in order to encourage future cooperation by the contempt law. That's important to just bear in mind what the context is of these two cases, because that one involves an appeal following Mrs. Justice Proudman not sentencing at all, except an indemnity costs order, having been deceived by the contempt law, who purported to comply, but in fact was doing the exact opposite, and claimed to be in terror of his associates, who are fairly notorious, including Mr. Ablyazov, who he was in fact trying to claim £4.5 million pounds or dollars off, as was subsequently disclosed, and the appeal was in fact by the bank to this court, and a load of fresh evidence emerged, and it was a very large multi-million-pound international fraud from Mr. Justice Proudman from the Chancery Division, and Solodchenko is another.
I thought you were describing.
Sorry, that was Solodchenko. Yes, that was a multi-million-pound abstraction, $290 million in Kazakhstan. Sorry, then, but back to Otkriti. Otkriti is also.
Sorry, I've lost the thread of what you're saying to us. In Solodchenko, the point is made that freezing injunctions are made for a purpose, namely to prevent the dissipation or spiriting away of assets. In the example I gave a few minutes ago, I fully understand that if somebody fails to disclose that which enables somebody to police the freezing injunction as a consequence, or do so with the aim of spiriting away or dissipating assets, notwithstanding the freezing injunction, then that would be the most serious contempt, because it goes right to the heart of the freezing order jurisdiction and the requirements to give disclosure.
Yes.
Was Solodchenko a case of that type? I mean, I understand that the allegations that are made in the underlying underlying case in Solodchenko were about the extraction of money from a bank.
Yes.
But are you saying that what actually happened in Solodchenko is that because of the failure to give disclosure, somebody was able to spirit away or dissipate assets, or
that appears to be
where do you get it from? I mean, can you actually be specific about what I'm supposed to be?
I see. Well, getting into the facts of Solodchenko, they're quite complicated. The action was in fraud. It was the bank is, I think, in Kazakhstan. Mr. Kithriotis was the second defendant, and the other defendants included Mr. Ablyazov, chairman of the board, and Mr. Roman Solochenko, chairman of the management board. And Mr. Kithriotis was a British citizen living in Cyprus. And the claim is to do with certain bonds, about $290 million worth, US, misappropriated and end up in British Virgin Islands companies. And they get a freezing order, a proprietary injunction, and related relief against Mr.
But to summarise, I mean, I've skimmed read down while you've been doing paragraphs 15 through to 25.
Yeah.
My understanding is that Mr. Kithriotis said, look, I'm a nominee who provides nominee services to BVI companies. I don't know. I'm an offshore nominee provider. I admit that I didn't initially provide the information that I should have provided. He then did. See paragraph 18. And then he served further affidavits and documents. And the judge sort of finds that he was in contempt because he plainly hadn't complied as ordered with the disclosure obligations. But I don't see any. I don't see any finding that suggests that he did so in order to facilitate dissipation or spiriting away of assets, or that that was actually the case at all. And if you look at paragraph 25.
She concluded that the contempt had been purged. And that he'd subsequently cooperated by providing a huge amount of disclosure at very substantial expense. And that was punishment enough. My Lord, I'm not entirely sure. I hadn't actually looked at it from the point of view of the extent of his involvement in the fraud, because what then subsequently emerges is that he has in fact disclosed, it subsequently emerges that was all a completely false foundation, and this court then sentences him to 21 months, pretty close to the maximum.
But is that because he's given false, it turns out he's given false evidence? Sorry, that he'd in fact...
It was certainly to do with failure to comply with freezing orders.
If you look at paragraph 27, it looks like...
The 61 really is what... I think 61.
Right, so this is a very different case. This
yeah.
So this is a situation where, in fact, in purported compliance with the order, the defendant had actually perjured himself.
Yes.
Right.
And in the end, 21 months, of which it was said that at least 9 was punitive, should there be any attempt to seek a review having purged and thereby complied, because he still hadn't complied. And he had aggravated it by deliberately placing the false evidence before the court of sentencing hearing and misleading the judges.
Is this your point that the observations you took us to, Lord Justice Jackson, in the paragraph 55, that any substantial breach of an order for...
Yes, it's 55. It's 55 is clearly a passage that's quoted by Mr Justice Richard Smith.
Yes, but I'm trying to unpick what 55 actually means. I mean, there are two aspects to a freezing order. One is breach of the freezing order by dissipating or spiriting away of assets.
Yes.
The actual contempt
Yes.
is breach of the order, the injunction. Don't dissipate your assets, and somebody does.
Yes.
I can understand why it's said that if done in any substantial way, is a serious matter that merits condign punishment, normally a prison sentence. There is a second aspect of freezing orders, which is the production of information
Yes.
to enable them to be policed. Is it right that the failure to provide information, if substantial, is also within the scope of...
Well, so it would appear from what was said there, and that's what's said by, that's the passage that is cited by Mr Justice Richard Smith.
So it's either type of breach of
So
the freezing injunction.
Yes. You get an instance of it in the other case that he cited, which was not, in fact, the source of that quotation, which was Otcritti,
right.
which is, in a way, a slightly simpler case. The gist of the non-disclosure aspect is there's a summary of the facts in the second schedule, so second appendix, and there were freezing orders made, which resulted in, first of all, on page 57 is the first breach, which is, and as you can see on page paragraph 11, some quite modest expenditure, which was in breach of a freezing order, and the judge decided would not actually of itself merit custody at all. But then we get to the second matter, which is ground 4, starting on bottom of page 57, going on 58 and 59, and you'll see paragraph 7 in page 59, there's over 2.7, or round about slightly over 2.7 million US dollars gets spent or paid away in breach of the freezing order. So that's substantial payments. And then the non-disclosure is at the bottom of the part B of ground 4, starting on the bottom of page 59. Sorry, starting on the bottom of page 60, I'm sorry. Start again. Bottom of page 60, ground 5, failure to disclose. This is the information part rather than the disposal part. There are provisions of disclosure, and it says in paragraph 20, after he became aware of the terms of the freezing order, Mr Khawaja failed in further deliberate and contumelious breach and defiance of it to disclose the whereabouts of the fraud proceeds or such assets represented in whole or in part were derived from the fraud proceeds as required by the order, to swear and serve an affidavit setting out the whereabouts of the fraud proceeds or such assets represented in whole or in part were derived from the fraud proceeds. So this is after judgment. It's been determined, as we see elsewhere in the judgment, in the main judgment, that Mr Gersemia has his share of the proceeds of the fraud is about 10 million, out of about 200 and something million. His 3 and a bit million of it is still unaccounted for, and he's refusing to say where it is, and in breach of the order. So it's a pretty blatant breach of a post-judgment freezing order. So he's moved the money and he's refused then to say where it's gone. And for that, he was sentenced to the principles that are then applied. The checklist is at the back of the judgment. Paragraph 16, page 47. On my findings, in the middle of the paragraph, Mr Khasemi's share of the fraud proceeds amounted to approximately $10 million US. Of that sum, 2.5 was paid over to Mr Kersey, a further 3.5 more recently been recovered from Jasper, and leaves a balance of an amount of more than 3 still unaccounted for even now. In those circumstances, the suggestion is genuinely remorseful as follows. Nevertheless, nor do I accept the suggestion that he right to say his life has been adversely affected by the proceedings. In truth, his life has been adversely affected by his own fraudulent conduct. Notwithstanding, I do accept he's endured a restriction on his liberty over the past 3 years, which I can and should take into account, bearing all the matters pleaded by mode of mitigation. I will allow a modest credit of 2 months against my starting point of 20, then allow a further discount of a third on the basis of admission of the contempts at the earliest opportunity, and the result is a custodial sentence of 12 months. Now that's for some pretty blatant breach, which included still, he hadn't disclosed where the 3 million had gone. I turn then to deal with Casella's further submission. This custodial sentence should be suspended. In particular, Mr Casella submitted Mr Khasemi was hopeful he might be able to repay the remainder of his share, i.e. 3.1 million US, within 120 days. And the judge very reluctantly acceded to that because the prosecutor of the bank was happy to go with that, and so on the basis that he actually restored. But apart from that, 12 months is the result, allowing for a plea of guilty. That is an extremely serious case of contempt compared with anything we've got here, and yet we've got admissions of guilt entitling some discount. We've got...
The admissions came in the affidavit of 27th of March.
Yes.
They didn't come any earlier.
No. My Lord, the point is made about that. The contempt applications were served, I think, in around about the beginning of February. She was not represented except by me once and by Mr Barclay once, both acting as direct access in respect of particular hearings on particular matters, not in any way attempting to grapple with this, not instructed to grapple with this. And it's therefore not until about 10 days before the hearing, thereabouts, that she was able to secure representation, although legal aid had been, she'd been told by the judge.
She'd been granted legal aid, had she not?
Yes,
by order.
Exactly. She'd been told that in February by the judge, and she had then obviously she's entitled to it. She's going to use it. There's a point rather surprisingly made against me that it's her, because she decided not to pay for it privately. That's the only reason why there was an adjournment application. I will find that very difficult to follow. There was an adjournment application because we found that we had less than 2 weeks to go. The deadline for the service of evidence was either imminent or even possibly past, and only just legal aid allowed. Mr Justice Marcus Smith refused the application for adjournment, extended the time for the service of the evidence, and there was then a great deal of energy very, very long days, including the weekend, in putting it all together. And only when that was sworn and served on the 27th, the eve of the hearing, was everything then brought together. So it's not the absolutely earliest possible moment, but it is, in my submission, about as early as it practicably could have been, bearing in mind he's entitled to get advice and that the allegations were all very detailed.
Thank you. Mr. Hebb, I'm conscious of time.
No,
Mr. Roseman has quite a lot to say. Are you going to finish before
yeah, my last, I just want to mention Spring Aurum. Well, no, I just want to mention the case of Maximoff, in which Mr. Justice Hamblin quotes Mr. Justice Briggs on the subject of satellite litigation. Now, this was a case where it was completely futile contempt that was being proved. This is page 36, paragraphs 19 to 22. Which is on page 41. This was an asset disclosure. This is not a normal asset disclosure case, says Mr. Justice Hamblin. The claimant's central concern is usually the pool of assets the defendant has failed to disclose in the contempt proceedings, the means of punishing the claimant for his past breaches and effectively forcing him to come clean and disclose. Here, there's a striking absence of any real identified prejudice to the bank. Neither the Barman shares nor the Kiev River Port shares have been placed out of reach, nor was there ever any real evidence that meaningful assets had been concealed. And in sector guard, Mr. Justice Briggs stated as follows. Now well established in the light of the new culture introduced by the civil procedure rules, and in particular requirements of proportionality as part of the overriding objective, that it's an abuse of the process to pursue litigation where the value of a successful outcome is so small as to make the exercise pointless, viewed against the expenditure of court time and the parties' time and money engaged in the undertaking. The concept, next paragraph, that the disproportionate pursuit of pointless litigation is an abuse takes on added force in connection with committal applications. Such proceedings are a typical form of satellite litigation, not infrequently give rise to the risk of the application of the parties and courts' time and resources otherwise than for the purposes of the fair, expeditious and economic determination of the underlying dispute, and therefore contrary to the overriding objective as set out in CPR 1.1. And over the page, Mr. Justice Hamblin, I respectfully endorse those comments. An increasing amount of this court's time is being taken up with contempt applications. Claimants should give careful consideration to proportionality in relation to the bringing and continuance of such proceedings. In appropriate cases, respondents should give consideration to applying to strike out. Well, I haven't applied to do that. The general thrust of that is, in my submissions, pertinent to this particular case. Now, my Lord, the sentencing remarks are 158 to 161. The mitigation was accepted, included guilty pleas. That's a correct construction. That's paragraph 39.
So back to the
158 in the core bar. To 161. We have it's a the mitigation that was accepted included guilty pleas. There, that's at paragraph 39.
hang on, before we get there, sorry, if we're looking at the sentencing remarks, do you criticise what the judge says at paragraph 30 or 31?
Partly, my lord, yes. Because the flouting of the county court orders do not include the provision of the information which eventually is relied on to do with... What was the main thrust of the respondent's submission on all of this? Was that to do with the events of April of 2021, when the first company stopped trading and the second company began, and some money was taken out of the first company and paid into her pension and into the purchase of a car and various other things. That was all very annoying for the claimant, who considered at that point that he had an entitlement to the contents of the company, and considered that, well, we had yet to find out how he's going to put it, but that somehow the original agreement, the original verbal agreement to deal in the product from the original supplier extends on and extends on and extends on, which is yet to be established. But what actually was done there was not in breach of any injunction, was not unlawful, was subsequently discovered, but was not discovered as a result of any concealment, except possibly in the delay in provision of information between November and December.
When you say it's not unlawful, is it lawful for the director of a company to just help themselves to the company's assets for their personal expenditure?
No. Well, she transfers the business from one company to another company. At that time, she is the 100% owner of the business and the sole director of the business.
Is it in the interests of the company to transfer its business gratuitously to another company? I mean, I'm not sure it matters for present purposes, but I just quibble at the suggestion that even of a 100% owned company, one can simply treat the company's assets as if they're your own and do what you like with them. There are procedures that need to be gone through and duties that directors have even to wholly owned companies.
Well, she's entitled to declare dividends for herself. She's entitled to pay herself a pension. She's entitled to have her. I mean, if she is the sole owner and it is her business, she's entitled to buy herself a car, I suppose.
Okay.
But it's not in breach. Certainly not in any.
I have the point. It's not in breach of any injunction.
It is not in breach of any injunction.
I'm going to put a query over it.
All right. What is then majored on is the allegation that, for example, the settlement proposal that was made in June was dishonest.
Well, okay, before you get there though, sorry, if I look at 31 of the judge's sentencing remarks, after he's set out the law as he sees it, he then deals separately at 31 with the county court orders.
Yes.
And at 32 with the High Court orders, and in a sense, I think, pulls it together in 33, but he makes findings, certainly in 31 and 32, of serious and contumelious flouting of the orders,
well, my lord,
and indeed, I think in 32, in effect, he finds, as Mr Justice Mead had done, deliberate non-compliance with the disclosure order of Mr Justice Accaroli.
Yes.
You don't, in your skeleton argument, dispute those matters. So why are we not into the territory of that Lord Justice Jackson identified in Solichenko of a serious breach? Because
the level of harm here is significantly less, and the
so you accept deliberate breach, serious and contumelious flouting or deliberate breach, but you say what it's the level of harm which is the difference.
Well,
I'm trying to understand.
My lord, harm is certainly one of the factors. As the primary assessment of seriousness is contumely and effect, harm. The paragraph 31, in fact, is referring to a whole load of orders which are pre the order with the penal notice attached, and not actually laid as contempt.
No, but sorry, just being clear. The judge deals separately with the question of harm at paragraph 36.
Yes.
So
It's delay, effectively, is the effect of it. That's the harmful effect. And I accept that finding. I can't obviously challenge that. There is a delay occasion, but the actual period of delay involved is quite short, because the activity that happens in April, and then the offer that is made in June, are long before there are any orders made which are relevant at all.
Sorry, I have not understood that submission. We saw that the first order was made by Exoner Judge Gerald. I think it was 13th of May. My understanding of the facts is that that was not complied with. Instead, there was the open offer to settle, which was not accepted. And it was at that point that an application was made for an extension of time, which was granted. Now, the judge, as my lord has pointed out, carefully structured this judgment with, first of all, looking at what the principles are, which takes you from 26 down to 30. And I don't think I've detected in your submissions any criticism of his statement of the principles.
No.
Then from 31 to 35, he's dealing with why, how serious the, dealing with culpability, how serious the breaches were. Because the breaches were admitted,
yes,
save for 7 of them, and of those 7 he found 6 breaches to have been committed. But there was a whole schedule of other breaches which were admitted, but had been complied with by the time of the hearing before him. So the question for him was this deliberate, or was it inadvertent or technical, or there was some good reason or excuse for it? And he quite plainly finds, both in relation to the county court orders and in relation to the high court orders, that they were deliberate. And do you take issue with that? Because like my lord, I hadn't appreciated that was part of your submission.
Well, no, but what is part of my submission is that we need to focus on what is ground 2, is on what is actually alleged. And the breaches that were alleged to constitute the contempt are not breaches of the orders back in the spring or through the summer, because those were not orders that had penal notices attached, and those were not orders. The failure to comply and coming along and getting an extension of time.
Failure to comply with a court order without a penal notice does not expose you, usually, to the penalty of committal, but it's still a failure to comply with an order.
Well, yes.
Yes, and isn't that all that the judge is saying? There's been serious and contumelious flouting of the county court orders with the repeated need to seek the intervention of the court, to the extent that ultimately you get one with a penal notice attached. Was the judge wrong to reach that conclusion?
No.
And what he said, he's quite clear.
Yeah.
Later on, that what he's sentencing for is the breaches of the orders with the penal notices attached, which is what he's found to be the contempt. That's what he's sentencing for. But he takes into account, in looking at culpability, the history of the matter. Is that wrong?
Well, Lord, I've taken you through the facts,
yes,
and the mitigating features that surround that, which don't seem to have really fed into his thinking, and in my submission ought to have done.
Okay. Anyway, as I say, it seems to me that in 31 to 35 he's looking at culpability, and then in 36 he turns to harm. Do you want to say any more about culpability? No. Do you want to say any more about harm? I mean, I have your submission.
No, I think
you say there isn't very much harm.
I think I said harm. No, you have my position on harm.
Well, do you say the judge was wrong to talk about the risk of harm? what I mean, do you criticise what is said by the judge in paragraph 36? I mean, I think a few moments ago you said in essence what the judge is simply saying is delay.
Well, Lord,
which you say isn't harm. This is what I was trying to get at a bit earlier when I was trying to put some of the points to you. As I understand paragraph 36, what the judge is saying is the harm, in inverted commas, is delay in being able to, the claimant, the petitioner, was
yes.
unable to take the steps which they wanted to, which he says to secure his position, or the like, as early as the claimant would otherwise have wished to do so. And it seems again that the second part seems to be talking about delay in being able to persuade the court of a real risk of dissipation of assets. But he doesn't go on to say, but there was a dissipation of assets.
Well, he doesn't, no.
And he said the respondent succeeded in putting off the perhaps inevitable day for quite some time to her own advantage and to the obvious detriment of the petitioner. But I don't understand it to be said, maybe I'm wrong, that the advantage was monetary, or the detriment of the petitioner was monetary by reason of the contempt.
Well, my Lord, I don't understand quite what the detriment is there, apart from simply the fact of an element of delay, which in the context of the position overall, as I've explained it, is modest, really, when one's also faced with non-pleading of a case explaining what the remedy is that he's after.
Is this to do with delay in order to facilitate the diversion of business or the extraction of funds?
Well, it's not that. Here we get into ground two. None of that was alleged, and it wasn't pleaded, and therefore it wasn't, as it were, on the indictment. It wasn't there to challenge. So, saying in a broad sort of way, well, Mr. Johar's affidavit has not been challenged, which covers a whole story of things, when what we have to, you have to have some discipline in considering whether or not things have been proved which attract imprisonment. And that discipline is to identify the allegations clearly so that they can be met clearly. And nothing of that kind was on the notice of application. There is obviously scope for the judge. The judge has to know what the background is, and obviously the background is relevant. But the actual, I mean, it was, if she was being sentenced for having bought the Mercedes for her own benefit in April, with £65,000 of the company's money at that stage in the situation, well, that wasn't a contempt that had been alleged, and I don't see how it could have been. If an allegation to that effect had been framed, one would have been able to meet it, but it wasn't. What's being alleged is that failure to comply in November, which is the deadline set by the Parfit order, with the enormous task that she had been set, that is the contempt which is being punished. Well, that's my submission on, that's really...
The question is, was the judge wrong to say in paragraph 36 that there was either obvious harm or risk of harm caused by the non-disclosure? Are you saying he was wrong to say that? I mean, I'm trying to understand, you see, why... I'm trying to understand why you say
Well,
the judge was wrong, either in principle or in his weighing of the factors, or in the result he reached. It has
well,
to be a bit more granular about it.
because he looked at the contempts that were shown, and even in the background and the context that they were, to finish up, allowing for a guilty plea with 8 months is too much. He identifies a risk of harm, and it's rather difficult to discern exactly what the risk is, apart from that it's some element of delay. There's certainly no financial loss identified.
Yes.
Well, those are my submissions.
Did you want to say anything about the ground of dealing with the County Court and High Court separately? That's one of your grounds of appeal.
Well, yes, it's a totality.
It's a totality.
Totality rules, and so therefore that kind of getting granular about whether things are consecutive or is a bit.
Your point is that 8 months overall is too much.
8 months overall is too much.
It doesn't matter whether
Yes,
you...
my lord, this is all been about demands for information of one sort or another. The whole thing, it's said in my learned friend's skeleton argument that it's been like pulling teeth without an anaesthetic. Well, my lord, normally the patient is the one who suffers.
Yes, I noticed that.
And that's Ms Stefanova.
I have one other question for you, Mr Howard. You said in the opening that you would identify the relevant principles by which we could interfere. Is there really, I didn't detect when we went through the authorities, any authority which particularly identified that, but is there any dispute that the principle is you need to persuade us that the judge was wrong, that's the word in the CPR,
Yes.
and that you can be wrong in sentencing if either you're wrong in principle or you've taken account of irrelevant matters, or you've reached a result which is just outside the range of reasonable results that a judge could properly come to on these facts.
Absolutely.
Is that what it comes to?
It's very well summarised by Lord Justice Arnold in the decision to which my lord is a party. He says he deals with exactly that, and he says that it's basically the same as manifestly excessive. It's and on a page I didn't look at, paragraph 124. Essentially the same test as the manifestly excessive test applied by the Court of Appeal and Price. It's on the page 128, paragraph 1, 2.
FCA McKendrick, cited at 124, error of principle, immaterial factors, reached decision plainly wrong outside of range of decisions reasonably open to a judge.
Exactly.
Well, I think that must be what I had in mind, because that's almost what I said.
You've almost quoted it without... Yes, it's graven on all our hearts, my lord.
You don't dissent from that. That's the test we
I
have
couldn't
to
possibly.
Do you say that this case crossed the custody threshold?
This is a value judgment. Obviously, I'm not going to concede that it does.
Well, if you say the judge...
I don't know.
Do you say... I mean, let's be clear about this. Are you simply saying... I mean, there are two possibilities. I mean, are you saying the judge was wrong in principle to impose a custodial sentence? Or are you simply saying that he was wrong to impose a custodial sentence of the length which he did? I mean, the first is a point of principle because the authorities make it clear that you should not impose a custodial sentence unless no other punishment is adequate.
Yes.
Now, I did detect throughout your submissions a flavour of you saying that this was not a case in which the custody threshold was passed.
Well,
so I want to be very clear about what you're actually saying.
Well, my lord,
while you're thinking about that, can I ask you, which of those three boxes you put your appeal in? Is it wrong in principle? Is it because he took account of factors he shouldn't have done? or is it because it's outside the reasonable range?
Well, in my submission, there's a flavour of him taking into account that which he should not have done, in the sense that the background, he's given too much.
That's your ground two.
Weight to that's the ground 2 point. Yes.
Too much weight to background.
Too much weight to background, which was not on the indictment, and therefore the whole process couldn't be properly engaged to meet it, to address it, to even identify precisely.
So that fits in the second box, taking account of wrong factors.
Yes, it does. Yes, it's also, say, manifestly excessive, bearing in mind when you look at really what was happening, what this contemnor was being pushed to do at the stage that she was being pushed to do it, which was when she had run out of steam in terms of paying lawyers, and she was therefore on her own.
Third box, outside the range of reasonable decisions, I think.
Stretch.
And what about, do you say, this goes back to my lord's
Sorry,
question.
I didn't understand your last.
My lord, yes, I would say so.
Well,
I'm sorry you're putting me.
Well, we've identified with your help, which has been of great assistance, Mr. Howard, that you say that this sentence is wrong, because you have to say that.
Yeah, of course. Yeah.
We've identified that, as set out in FCA McKendrick and picked up by Lord Justice Arnold in BMF number 4, there are 3 boxes in which you can put wrong for these purposes, wrong in principle, wrong factors taken into account, or just manifestly outside the reasonable range of sentencing decisions. I'm trying to tease out which of those boxes you put your case in, and I have got the point that ground 2 fits into box 2.
Well, my lord, let's go for it. It's Mrs. Justice Proudman's response to the position as it was presented to her misleadingly.
Yes.
Was applicable to this. The cost and effort and work done and it finally being purged and complied with is this case.
So you say a custodial sentence in those
circumstances, in which case, no, not required.
Was wrong in principle.
And if not required, then therefore wrong.
So that fits into box 1.
Yes. Sorry, you got me there. Thank you. Is there anything more that I can help you with?
No, thank you very much, Mr. Howard. Well, I suggest, given the time, that we rise now and resume at 10 to 2. Thank you very much.
Court rise.